Good afternoon, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Today we're going to talk about a case in Ohio. It's a case about a stalker. There were plenty of warnings, and then there was murder. Let's talk about it. Good day, Crime Talk aficionados. Today we're talking about the case in Ohio, which involves the accusation made against Dominic Swopes, S-W-O-P-E-S. He is a 27-year-old man that has been charged with 2 counts of aggravated murder and 1 count of aggravated arson. And so the story goes, and it's just developing. Mr. Swopes was brought in for questioning and then released. He was then arrested a few days later after the police continued to follow him and further their investigation. Mr. Swopes is alleged to have killed Rebecca Pletnewski. She's a 41-year-old nurse and her 8-year-old daughter, Olivia. Apparently, Mr. Swopes stalked Miss Pletnewski. He apparently made her feel uncomfortable that she warned family and friends in the neighborhood about what Mr. Swopes was doing, but it does not appear as though at this time that she had actually gone to the police. But there were early signs.
He became a subject of interest that day because what family and friends had told us that she had warned, Rebecca had warned them or told them of instances of potentially stalking by the neighbor, and so he became our primary suspect at the time. After we talked to the family, who do you think could do something like this? And that was the first name that came up.
Mr. Swopes is now charged with not only going in and killing Miss Pletnewski, but then setting the house on fire so that her 4-year-old child died in the flames. Miss Pletnewski had another daughter that was staying over a friend's house and was not injured. Ladies and gentlemen, what is it in Ohio these days where people are, is there something in the water in Ohio that people are going around killing people? And yes, this could happen anywhere, and I'm not saying, I'm joking. So it makes you wonder if there's something in the water. I don't know. But this is going to be an interesting case to see because we want to know why Mr. Swopes did what he's alleged to have done. If that is in fact happened, obviously we'll give him the presumption of innocence. He's been given a public defender. So Mr. Swopes was brought in for his initial appearance. And let me break this down, and it may vary from jurisdiction to jurisdiction, whether you're in state court, federal court, municipal court. But on a felony charge, normally everyone accused of a felony charge when they are arrested is brought before a magistrate or a judge and advised of what the investigation that is holding them is going on. And the judge will usually set a bond at that time. And then the government will have 48 to 72 hours for filing of charges if you remain in custody. For obvious reasons, if people are in custody, their lives are on hold, their liberty is at stake, people need answers. If you bond out, normally that takes a little bit longer. If you're indicted, you don't get a preliminary hearing. But if you proceed by a complaint or information, then the matter is set for a preliminary hearing, which is simply a screening device to determine whether probable cause exists. Probable cause is a very low standard in a criminal court. It's simply would a reasonable person believe that a crime was committed and that the person charged had something to do with it. Normally at the preliminary hearing, all evidence has to be viewed in the light most favorable to the prosecution, drawing all inferences in favor of the prosecution. So really, a lot of preliminary hearings are waived, okay? And if you get indicted, the grand jury's already found there's been probable cause because they indicted you. But you can ask for a probable cause review in some jurisdictions. And simply the judge would review the grand jury transcripts and see if, in fact, probable cause existed. After indictment and preliminary hearing, the matter is set over for an arraignment. An arraignment, that's where you enter a plea of either guilty or not guilty. And if you enter a plea of not guilty, normally the state has a limited time in which to get you to trial. If you don't, that's a violation of your Speedy Trial Act. So, for example, in Colorado, on a felony matter, from the time you say not guilty, it's 6 months from the date you say not guilty, the state must get you to trial. If they don't, the case would be dismissed. Rarely ever happens. They will oblige with a trial. And in that meantime, their motions are filed. The judge will say you have 30 to 45 days to file motions. You have a motions hearings where the judge will determine legal issues about what evidence comes in, what doesn't come in, and then ultimately a trial. So that's kind of the process. So when somebody gets arrested, say, for example, in a felony case, you're looking from the time you get arrested, you're advised, you have come back for filing of charges, you're set up for a preliminary hearing if you're eligible, you set it for an arraignment. By the time you get to arraignment, possibly 2 to 3 months could have passed. And then you have 6 months to get to trial, and those dates can be continued depending on the court schedule, discovery, investigations that need to be done, okay? In the federal system, it's a little different. You get indicted, okay, and normally they indict you. They can still do it by a complaint and information, but then they ultimately indict you because it's required under the Constitution to do that. And then the government has 70 days to get you to trial if you are in custody. So the speedy trial varies, and that can be delayed based upon filing of motions, tolling, ends of justice type continuances, okay? So the case of Mr. Swopes is going to take some time to get there. I don't think it will resolve as quickly as, for example, Mr. Watt's case resolved, since that one was resolved even before the preliminary hearing, which rarely ever happens. My guess is that this will take a little longer, and we'll get to flush this out a little bit. And I bet there'll be some actual defenses, possibly some mental health type defenses in this particular case.
Do you understand the nature of the charges against you, sir?
Yes, sir.
And do you understand the potential punishments?
Yes, sir.
The district attorney only asked for a $1 million bond, knowing that Mr. Swopes would be completely unable to do that. But the judge went above and beyond to make sure that didn't happen and set the bond at $5 million. So he's going to be indicted. He is going to be brought before the court for an arraignment very soon. We will be following this. This case is going to be interesting because why do people go and kill women and children? It fascinates me. I hope it fascinates you. We want you to talk about it. If you like the channel, please hit the like button. Please subscribe and leave a comment. We do read the comments, and we try to go through and approve and or talk to everyone on there as well, at least at some point. So I appreciate you listening. This is Crime Talk. We'll be back soon. Leave us a comment. Have a great day.